Good morning, everyone. We're going to get started in just a minute. We're still seeing some people register and sign on, so we want to give people just another minute or two to join us so we can have as many people as possible, but we will get started in just another minute or two. Okay, since we do have quite a bit of content to go over this morning, I'm going to go ahead and start with some of our housekeeping items while people still continue to sign on. So good morning again, everybody, and welcome to the harassment prevention training on the last day of the League's conference. I hope you have enjoyed it so far. Some quick housekeeping items. First, you guys will be muted for the duration of the presentation, but please feel free to ask us questions at any point during the webinar. You can do so by typing them into the questions box that you should see in the right-hand channel of your screen in kind of that control panel area. We'll be monitoring those throughout and pausing to take them at a few points throughout the webinar. So you don't feel like you have to hold them till the very end. Please type those in at any point. So in order to get credit for this webinar and get your certificate, first you must have your own login. So if you guys are joining together right now, make sure that you drop off immediately and go register yourself and join that way so that we can track participation. Otherwise, we don't know that you're on, unfortunately. You do have to be present for the full training. I promise we'll get you out of here right at 10:30. Since I'm sure you've got other things to do, but you do have to be with us for the duration of the training. And then we will be asking about 6 questions throughout the duration of the webinar via a polling function. So you do have to respond to those in order to get credit. We aren't grading them. You don't have to get the right answer, but you do need to participate just to make sure that you're thinking about these ideas and participating throughout. A couple other notes before we jump in. You'll be receiving your certificates electronically this time, but please expect those by the end of the month. If you are an attorney joining us and looking for MCLE credit, please reach out to us and let us know that you were on the session and share your bar number with us so that we can get you the proper documentation for that front as well. And if you have any questions or concerns, please reach out to me. I'm Melissa Keene. You can see my email on the screen there. So don't hesitate to reach out to me if you have any questions following the presentation or any concerns. One other quick housekeeping item not on that slide. We will be sharing the full slide deck with you all as follow-up to this presentation via email as well. As I noted, we'll be going over a lot of content. We want to make sure you guys have that as a reference point after the fact. Real quickly a little bit about the Institute for Local Government and how we connect to the League. So we are a statewide nonprofit that's an affiliate of the League of Cities, as well as the California State Association of Counties and the California Special Districts Association. We provide practical and easy to use resources so that local agencies can effectively implement policies on the ground. We do this in a variety of areas. We provide a lot of training and education, such as the webinar you're all on this morning. In addition to that, we also provide technical assistance and capacity building, as well as convening and facilitation services for our local government partners statewide. And we do this in a variety of areas. You can see our program areas there on the left. Our first main pillar is what we call leadership and governance, and that covers a number of things, including this training this morning. So we do provide the state mandated ethics and harassment prevention trainings for you all. We have a whole host of materials for people who are new to public service. So as you guys have new council members joining your team or things like that, we have a lot of that kind of basics information that they need. And then we also do a lot of provide resources and training and facilitation around how to operate more effectively as a council and as a team, governance team with your staff. In addition to leadership and governance, we focus on civics education and workforce, which helps create a pipeline to public service and facilitate municipal school partnerships, and really work with young folks to make sure that they know the local government as a career path for them. We have a pillar that focuses on public engagement, and so this is a whole host of things related to community engagement. Right now we're doing a lot around virtual engagement, and this really applies to a number of different topic areas, whether you're updating your housing element or your general plan, or you're just looking for feedback on parks or on budgeting issues or things like that. There's a whole host of information we have there. And then lastly, we also focus on sustainable communities, which helps connect local governments to things like cap and trade funding. Again, we do a lot around housing and land use in that space. And we also run an award program for efforts to reduce greenhouse gas emissions, save energy, and implement sustainability best practices. So if you're not familiar with us, definitely encourage you to go to our website, check out all of our free resources, and see how they might connect to things that your agency is working on. So with that, I'm going to turn it over to Rebecca Green with League and ILG partner Richards, Watson, and Gershon. So Rebecca, I'm going to go ahead and make you the presenter now. So you should be able to see that pop up in just a second.
Okay, can you see what you're supposed to be seeing and hear me?
Yes, and yes.
Okay, perfect. All right, so let me move to, whoops, there we go. All right, well, thank you everybody for being here this morning and spending your Friday morning learning about harassment prevention. My name is Rebecca Green. I'm a labor and employment attorney with Richards, Watson, and Gershon, which is a California firm that serves public entities throughout the state. Couple things. So I will be stopping periodically throughout the webinar to answer questions. I often find that if people save all of their questions till the end, you're probably tired at the end. You want to go get another cup of coffee. You may have forgotten a question that was relevant earlier in the presentation. So as I stop periodically, I think it would be great if you could then ask at that point whatever questions you have. But I also realize that some people don't have questions until the training is over. So I will try to end about 10 minutes early, and then you can ask any additional questions. The only other thing I'll say is that so there will be a number of hypothetical scenarios throughout this training. They are all real life examples that I've encountered in my work. And I say that because I think knowing that always makes them a little more interesting. But I'll also say that I have changed any kind of identifying detail, and that a lot of these scenarios are actually very common. So if you think that you recognize any of them, I can pretty much guarantee you that they did not involve your agency. These are just scenarios that tend to come up a lot. All right. So why are we here today? There are a number of laws that require us to be here, and some of these will apply to each of you. Sometimes more than one will apply to each of you, but I'll just go through them so that you kind of understand what requirements you are going to be fulfilling today. So AB 1825 was a law that required all supervisory employees to attend 2 years of sexual harassment prevention training every 2 years. And Supervisory employees is interpreted by the law to really mean anybody who supervises anybody else. So a lot of people think that this is limited to managers, department heads. That's not true. You can be head of a working group. You can have one person working under you, and that does make you a supervisory employee. AB 1661 requires all elected local agency officials to attend 2 years of sexual harassment prevention training every 2 years. SB 778 requires all non-supervisory employees, so in other words, all employees, to attend 1 hour of sexual harassment prevention training every 2 years. AB 2053 is an interesting one that says that harassment prevention training must include a component on the prevention of abusive conduct. As we'll talk about at the end of this training, abusive conduct is not illegal. Harassment obviously is. Abusive conduct is not, but the training still has to include a component on it because the law is trying to foster a better workplace. And then the most recent of these, SB 396, requires that harassment prevention training must include a component on harassment based on gender identity, gender expression, and sexual orientation. So a lot of you are probably thinking, why am I here? I know how not to harass people. And I'm sure that's true, but you also have an obligation to help prevent harassment. And the law requires all employers to take affirmative steps to prevent unlawful harassment. That includes ensuring that all employees are properly trained, adopting policies designed to prevent harassment, and then informing employees of their rights. So all employers have to post a poster on discrimination in the workplace, including the illegality of sexual harassment, in a prominent and accessible location. So that can be a lunchroom, a break room, in the hall where a lot of people would walk by, pretty much anywhere except, a private office where people aren't going to see it. And there's now a requirement that employers have to post a poster on transgender rights in the workplace in a prominent and accessible location as well. And that extra requirement was added just because of the very high incidence of harassment against transgender individuals in the workplace. Why is it important to understand harassment, even if you are one of the many people who know how not to harass someone? So you need to understand what constitutes unlawful harassment so that you can recognize it and avoid it. And many people who don't understand what harassment means will either underreport or overreport harassment. So I see both of these things occurring a lot. Harassment tends to be underreported when employees don't understand their right to a harassment-free workplace. So they may experience or see things going on that really are harassment, but because they don't understand what harassment means, that it's illegal, that they have the right not to be harassed, they don't report it. And if they don't report it, then nothing can ever be done to stop it. On the other hand, I see harassment sometimes overreported when employees use the word harassment to mean any kind of unpleasant or unfair treatment. And I want everyone to understand that when I say it's overreported, I am not accusing anyone of lying about harassment. I'm talking about people who experience unpleasant to extremely unpleasant, intolerable behavior that should definitely be dealt with, but doesn't necessarily constitute harassment under the law. So part of this training is to educate yourself so that you know what procedures to follow if you witnessed harassment, receive a complaint of harassment, and experience harassment. A lot of people think that only supervisors, managers, human resources will receive complaints of harassment. That's not true. If you're, just somebody's coworker, you may hear them talk about a harassing incident, and you do have an obligation to report it at that point. You yourself don't have to do anything to actually deal with it, unless you are a supervisor or human resources, but you would still need to report it. And the more you know, the better you can protect yourself, anyone who works for you, coworkers, and the agency that you work for. So one of the most important things is to adopt policies. So anybody who's listening today who is in the position to adopt or implement a policy really should do so. This is going to protect everyone, employer and employee. It's still surprising to me when I see workplaces that don't have harassment policies, and it just makes it a lot more difficult to enforce harassment policies if it's not in writing. The other thing is that your employers are allowed to adopt harassment prevention policies that are more stringent than the law. So the law sets forth actually a pretty narrow definition of what harassment is. And that means that if you experience harassment under the law, you can go sue in court. But employers can expand that definition of harassment and make it broader so that you can still be violating an agency policy, even if you're not breaking the law. So for example, there may be a zero tolerance policy on any kind of sexually inappropriate material, requiring employees to attend harassment prevention training more often than the law requires, adopting policies prohibiting abusive conduct, even though abusive conduct, as we discussed, is not yet prohibited by the law. So these are just all examples of things that aren't prohibited under the law, but that it's very common and, in my opinion, a good idea for employers to adopt as part of their internal policies. And then you have to be equipped to take action. Otherwise, this training is fairly meaningless. Understand the potential consequences of harassment, including discipline in the workplace and potential civil liability in courts. Taking responsibility for your individual role in preventing and addressing harassment, and then communicating to employees whom you manage or supervise what their rights and responsibilities are. And this may seem counterintuitive to some of you who are managers or directors, but the more employees understand their rights, really the better that is for the employer and the agency. We need to get everybody on the same page to understand what harassment is and what behavior constitutes harassment and what we can all do together to prevent it. So what are some of the consequences of unlawful harassment? Unlawful harassment costs employers collectively over $2 billion per year. That's a fairly current figure. The cost goes up every year. And two things I'll say. Actually, it's one main point, which is that number is going to be that number is a lot lower than what it probably is, and the reason is that in the private sector, harassment settlements are confidential. So this number includes public sector settlements and court verdicts. But there's a whole other category of money that my guess could be almost as high as this alone, that's private sector settlements. But that's just money, and monetary costs are only one consequence. So other non-monetary consequences include stigmatization, both of the complainant and the accused harasser, absenteeism, not just of the complainant and the accused harasser who's often put out on administrative leave, but other employees in the workplace, because as much as we try to keep these investigations and complaints confidential, the reality is people talk, and we can do everything under our power to prevent it. And even if nobody knows exactly what's going on during a harassment investigation, often they can sense it, and that results in lower productivity, low morale, workplace strife, people are taking sides, and of course there's a huge emotional cost to the victim, and that can spread throughout the workplace. Okay, so now we're going to talk about just kind of a broad overview of anti-harassment law. So federal anti-harassment law really began in 1964, and at that point it was harassment based on a person's sex or race. It also includes religion, color, and national origin. As many of you may be aware, in June, the U.S. Supreme Court decided Bostock versus Clayton County, Georgia, which held that the definition of sex under the 1964 Civil Rights Act also includes protections for sexual orientation and transgender status. So those are now protected under federal law. Then in 1986, the Supreme Court held that sexual harassment in the workplace is a form of sex discrimination prohibited by the Civil Rights Act. So sexual harassment kind of grew out of the idea of harassment based on a person's protected category. Many Americans had never heard of sexual harassment until 1991. When I'm doing this training in person, I always ask for a show of hands for who knows what the significance of 1991 is. It's a good gauge for kind of measuring average age of the audience. So if you've already thought of it or don't know what it is, that was when the Anita Hill hearings against Clarence Thomas occurred, and sexual harassment, I think, became more of a common household word. So California anti-harassment law was passed in 1959, began with the Fair Employment and Housing Act. Although if you look back to the California Constitution, which was ratified in 1879, it prohibits discrimination on the basis of race, and it's now been interpreted to prohibit race-based harassment as well. So I think there's a theme here, which is that harassment is actually not a separate category than discrimination. It's one aspect of how people are discriminated against, and that's by being harassed. Other laws are occasionally used as the basis for harassment claims in California. The California Family Rights Act, workers' compensation laws, and the Labor Code. I very rarely see those laws invoked in harassment claims, but it does happen. So in California, harassment is illegal if on one of these following bases. I'll read through it quickly, and then I'll just explain a couple of them. So it's race, national origin, color, ancestry, sex, sexual orientation, gender identity, gender expression, physical or mental disability, religion or creed, medical condition, genetic information, marital status, pregnancy or pregnancy-related conditions, veteran or military status, and age. I want to just explain, so a lot of these terms are very straightforward. I want to just explain some of them that are commonly misunderstood. So starting from the beginning, so race under SB 188, which is a very recent law, now does not only include actual discrimination on the basis of a person's race, but discrimination on the basis of characteristically associated with a particular race, such as hair texture and style. Color is different from race. Color literally means the color of a person's skin, regardless of what their race is. Gender identity and gender expression are how one identifies regardless of what sex they were assigned at birth. Gender expression is how one outwardly expresses oneself in terms of gender, and that does not necessarily match with one's biologically assigned sex. It may be male, female, both male and female, neither male nor female, but any kind of gender identity or gender expression is protected. Another one is creed. So creed, the common word or the common meaning of it is belief. Creed doesn't cover all beliefs. It doesn't cover political beliefs, for example, but it does cover any extremely personal, intrinsic belief that is so important to a person, it rises to the level of religion. There have been very, very few cases where people successfully sued on harassment or discrimination based on creed. But it's there, and so we should understand it. And then finally, I think age, probably most of you know this, but age discrimination is relevant to people who have reached the age of 40 or above. If you are under 40, no matter the scenario, you cannot be discriminated against or harassed on the basis of age. Somebody makes fun of you because you're 25, that's not harassment. So this brings me to our first hypothetical. And we're going to pause after each hypothetical for you to think about it and answer the polling questions. I'll give you about a minute, and then I'll explain not only why one was the correct answer, but why the other one was the incorrect answer. So George is a supervisor in the finance department who constantly screams at Alberto, his assistant. He tells Alberto he is stupid and lazy, and humiliates him in front of his coworkers, even when Alberto has done nothing wrong. One day, George threatens Alberto, "If you don't do what I want, I'm going to make sure you never have a job again." Alberto suspects that the reason George has singled him out is that George used to date Alberto's sister, and she cheated on him. Is George engaging in unlawful harassment? So take a minute, and then I will come back and let you know.
Great, Rebecca. So I'm going to go ahead and launch this poll for everybody. So hopefully you're seeing that pop up on your screen as a multiple choice question with the options that Rebecca just outlined there, yes, no, or that you need more information. The vast majority of you have already participated, so we'll just give this another few seconds here for any last minute responses to come in. And just a reminder, in case you joined us late, this is how you get credit for today's training, is by making sure that you respond to these so that we know you're present and accounted for. Let's go ahead and close this one out, and then I will share the responses with you all quickly, just so that you can see how other folks responded. And Rebecca, can you see that up as well, the results?
I actually can't.
Okay. Let me read them for you then. So
Great.
We have 63% of the respondents said yes, 26% said no, and 11% said they need more information.
Okay. So the correct answer, in my opinion, is B, no. And here's why. Here's why it isn't yes. So I think we can all agree that George is a terrible supervisor. You should never be screaming at somebody. You should never call them stupid and lazy. You should never humiliate them, threaten them with not giving them a job again. All of that is horrible supervisor behavior. Could be grounds for high level of discipline, even termination. But if we look at the prior slide, it says harassment is illegal if on one of these bases. And it seems, from all of the information that we have, it seems that George is being mean to Alberto because of this private relationship that George had with Alberto's sister. She cheated on him. George is angry at Alberto. So while he is engaging in horrible behavior, possibly abusive conduct, it's not unlawful harassment. The reason that I added C, so I used to only have options A and B in this hypothetical, and somebody who probably was actually not a lawyer but had this lawyer's brain started giving me all these what ifs, and said, well, Alberto suspects that the reason George has singled him out is that George used to date Alberto's sister. But what if that's not the real reason? So we would have to conduct an investigation and try to figure out, was this really unlawful harassment, or was Alberto right and it was because George used to date Alberto's sister? So I would say no, but I think it's fine if you said C, I need more information, and it's fine if you said yes, and now you know why that wasn't correct. All right, here is another hypothetical. So Melinda and Anna are friendly coworkers in the finance department. They both have the same title of senior supervisor. One day, Melinda tells Anna that she has started dating someone new. Anna is very excited and asks, what's his name? Melinda says that actually her name is Kristen. After that day, Anna never speaks to Melinda directly, but constantly makes negative comments about gay and lesbian people in Melinda's presence. Is this unlawful harassment?
All right, I'm going to go ahead and launch this next poll for you all. So hopefully you see that popped up on your screen. Unfortunately, due to character limits, we can't have the full scenario visible here, but you should see the responses at least. And again, almost all of you have already voted, so we'll just give this another few seconds here for the remaining few people to respond if needed. All right, I'm going to go ahead and close this and then share the results with everybody. So 87% of you said yes, 6% said no, and 7% said that they need more information.
Great. Okay, so it sounds like most of you were correct. The answer is yes. And the reason is that Anna's behavior changed when she found out that Melinda was dating a woman. So this would be considered harassment on the basis of sexual orientation. Now, if you said no, I can probably guess what the reasons are just based on this presentation that I've given live and some comments that I've gotten, which I think are very valid. And one of them is that Anna never addressed Melinda directly. She didn't say anything mean to her. She didn't jeopardize her job. And that's not the only way to harass someone. So making negative comments about gay and lesbian people in her presence where she can hear does constitute harassment. Now, as we'll see a little bit later, it would depend on how often she makes those comments. I said constantly, so to me, that's probably often enough to constitute harassment. But there are some people who said, I need more information. Does constantly mean once a month? Does it mean once a day? So that is, that's that one. Okay, before we then go into the details of what is sexual harassment, I want to pause. Have there been any questions?
Yes, I see one come in. So this is more about reporting, and you may get to this in a bit. But the question is, if they get a complaint regarding an employee who reports to the council and Sorry, if this is your question, please feel free to clarify this. So as it stands, it reads, if I get a complaint regarding only one of two employees who report to the city council, the city manager, do I report it to HR or the city attorney? So if I'm reading it correctly,
there were a lot of titles in there. Can you read it again?
If I'm interpreting it correctly, and please feel free to correct me if you were the person that asked this question, I believe it's asking if they get a complaint about the city manager, would that be reported to HR or to the city attorney?
That's entirely an internal policy decision. I can tell you that what is most common is to report to HR. And usually if it's the HR director or manager who is being accused of harassment, it would be reported to the city manager. And I've seen instances where, okay, if it's both the city manager and HR, then you would report it to the city attorney. Again, there's no legal requirement in there other than reporting it to somebody who can actually do something about it, which may mean investigating them on their own, or it may mean hiring an external investigator and not reporting it to the person who is accused of harassment.
Great. I hope that we did just get a clarifying question about the most recent hypothetical. The question is, would it have been unlawful harassment if Melinda did not make negative comments, but simply ignored Anna in the workplace?
It's a really good question. And I think under the law, probably no. Now, there are different ways of ignoring people. There's just I don't want to be friends with you anymore, and maybe you pass them in the hallway and don't say hello, or say hello and keep on walking. I don't think that would rise to the level of harassment. If it included shunning, nasty looks, getting other people to not talk to her, that probably would rise to the level of harassment under the law. But it is very, very difficult to form the basis of a harassment lawsuit just based on somebody, ignoring somebody else. It has to be some more severe behavior than that. Now, that scenario would be different if Anna was supervising Melinda. In that case, the supervisor just deciding that they're not going to talk to you anymore because of your sexual orientation, I think most likely would be harassment. But in this particular scenario, I don't think so.
Great. We did actually just receive a quick follow-up to the initial question around reporting instances with the city manager. And the question is, as follow-up, is what if HR reports to the city manager? So would you still report the incident or behavior to HR even if HR reports to that person? Does that make sense?
It does make sense. Again, so this is entirely dependent on what the internal policy is, but I'm trying to sort of take a survey right now in my head of what I've seen as the most common scenario, and I would say most commonly, yes. You would still report it to HR, but that doesn't mean that your agency can't or doesn't have a different policy. In that case, it could be the city attorney.
So it would be best to likely check with any internal policies or protocols in place at your agency, if I'm hearing you correctly.
That's correct. And I think, that one of the aspects of a sound internal harassment policy is that there should be a very clear reporting structure. Usually the default is to report it to HR or to a manager or supervisor that you work under, who would then report it to HR for you. That's sort of the baseline default. Again, not required by law, just what we tend to see. And then, if HR is implicated or if the city manager is implicated, then it's really, I've seen a lot of different variables as to how the reporting works. But it is not uncommon, and I would say probably more common, to report a city manager to HR, even though I understand sort of cognitively why that may not make any sense. Anything else?
That's all I'm seeing right now, but just a good reminder to everybody that if you have questions as we're going through this, we'll be stopping a few more times to respond, so please drop those into the questions box as they come up.
Great. Okay, so now we're going to talk specifically about sexual harassment. So sexual harassment is a form of sex discrimination. You are singling somebody out on the basis of sexuality. And there are two kinds of sexual harassment. So one is quid pro quo. I think after 2019, that's a word that most people know what it means. It was kind of the word of the year, used a lot in the news. But in the sexual harassment context, it means receipt of a workplace benefit in exchange for a sexual favor, or denial of a workplace benefit as retaliation for refusal of sexual advances. So workplace benefits aren't just hiring, firing, promotion, demotion. In other words, if somebody if somebody makes a sexual advance and accepting that sexual advance means that you are given better or worse work assignments, that is sexual harassment. So it's not just the sort of ultimate, you're hired, you're fired. And the second type is a hostile work environment. It's probably these days the more common type of sexual harassment. I often refer to the TV show Mad Men, which I think showed a lot of quid pro quo harassment. It was, if you do this for me, I do this for you. It's kind of, I want to put in quotes, old school harassment, not that it doesn't occur anymore. It absolutely does. But I think the difference is that several decades ago, nobody really thought about a hostile work environment. Something was only considered sexual harassment if it's quid pro quo, and now we've expanded our understanding of that. So this is a general definition of sexual harassment that applies to both quid pro quo and hostile work environment. It's a mouthful, and again, you'll be getting a copy of these at the end, so no need to take notes or memorize this. So sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. So that standard was adopted by the EEOC, the Equal Employment Opportunity Commission, and it's been adopted now by California state courts as well. So let's talk about quid pro quo sexual harassment first. So there are three elements that have to be present in order for it to be quid pro quo harassment. So the first is that the conduct is unwelcome. If it's welcome conduct, that's not harassment. Second, the conduct is sexual in nature. So as we discussed earlier, there are other kinds of harassment based on race, religion. But to be sexual harassment, it has to be sexual in nature. It can't just be somebody, calling you names. Submission to or rejection of sexual advances affects the terms and conditions of employment. So the most obvious is hiring and firing, pay raises, bonuses, but as I said before, it can also just include better work assignments, favoritism. So the definition of hostile work environment, you'll see the first two parts of it are the same as quid pro quo. So the conduct is unwelcome. The conduct is sexual in nature. And then the third one, which is different from quid pro quo, the conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive work environment. So what's the major difference then between quid pro quo and hostile work environment? And this is important. So one single incident of quid pro quo harassment can be sufficient for a sexual harassment claim. One employee says to the other, if you come into my office and kiss me, I'm going to put in a good word for you with the boss, or if you are the boss, I'm going to give you a good performance review. The employee says yes, and that does happen. The employee says no, and they're retaliated against, and let's say not given a good bonus that year. One time of something like that happening can form the basis of a harassment claim. Hostile work environment harassment requires that the conduct is severe or pervasive. So severe can mean one inappropriate touch. It doesn't have to be assault, but it would be something that is overtly sexual. Pervasive can mean less severe conduct occurring more frequently. So I'm going to give a couple examples. Let's say one supervisor, a supervisor grabs their secretary in the pelvic area. I mean, we have to be explicit here. That is severe. That would constitute a hostile work environment. Pervasive can mean less severe, but it would be conduct occurring more frequently. So let's say the supervisor walks past his secretary's desk every day and gives them a little squeeze on the shoulder. One time would not be enough to constitute a hostile work environment, but let's say that conduct is unwanted and it happens a couple times a day or even every day. So that's the difference between severe and pervasive. I find that hostile work environment is becoming a very common term. And I think it's important to recognize, what it means legally versus what it means in sort of common conversation. An abusive boss can create what we think of as a hostile work environment, mean coworkers. There are all sorts of things that can make a work environment feel hostile, but the real legal definition of hostile work environment does have to do with sexual harassment that's severe or pervasive. There are many different forms of sexual harassment. These are really just a few examples. So there's verbal, that can include sexually explicit language, requests for sexual favors, unwanted comments on a person's appearance, obscenities, jokes, comments using gender stereotypes, and those do not have to be directed at any particular person. If it happens often enough and it is not welcome in that audience, then it could be a basis of a harassment claim. Of course, we probably all know that sexual harassment can be physical, and it includes unwanted touching. It doesn't have to rise to the level of assault or even be overtly sexual. And I think everybody has different definitions of what overtly sexual means. I think, when I'm doing this live, I'll often take a poll, okay, who thinks that a shoulder rub is overtly sexual? I get about 50-50. So one example I like to use is poking somebody in the middle of the forehead. You just walk by them, you take your forefinger and you poke them on the forehead and keep walking. That would probably not be considered by any court and really most people to be overtly sexual. It's not appropriate workplace behavior. It's obnoxious. But but that's, that's something that probably, even though it's unwanted, would not constitute sexual harassment. And then visual would include pictures, posters, office decorations, cartoons, other humorous depictions. Whatever material somebody enjoys on their own is fine. If it's hidden in a desk drawer, it's probably not going to constitute sexual harassment. If it's displayed even in a private office, though, where other people can see, that could form a basis of a sexual harassment claim. So what does it mean that conduct is unwelcome? Because a lot of people think there's gray area here, and there's actually a pretty strict legal definition of it. So for conduct to be unwelcome, the challenged conduct is unwelcome in the sense that the employee did not solicit or incite it. So an employee does not have to say no in order to prove that the conduct was unwelcome or unwanted. If an employee complains of sexual harassment, the burden is on the accused person to prove that the conduct was not unwelcome. I find this one to be sort of one of the most commonly misunderstood aspects of harassment. People who are the subject of harassment investigations will often say, but the person never said no. And they don't have to. If you are accused of harassment, you have to prove that if it's conduct that was, sexual in nature, you would have to prove that the person you were doing it to actually solicited or incited it. So that means they gave consent, essentially. And soliciting can mean that the person says, will you kiss me? Inciting it, let's go on a date, let's have a relationship. So there has to be some sort of affirmative showing that the conduct was wanted. All right, another hypothetical. So Ted and Lily work together. One day, Ted walks past Lily's desk and says in a hushed voice, "If you give me a shoulder rub, you'll get a good bonus this year." Is this unlawful harassment?
Okay, so I'm going to go ahead and launch this next poll for you all. So hopefully you can see that pop up with the responses. And just to clarify, all you have to do is respond to these polls. Again, we're not grading them, so if you chose the wrong answer to a poll that has already happened, or don't choose the correct answer here, that does not count against you. You'll still get credit for attending. We just want to make sure that you're participating. And about 80% of you participate so far, so we'll give this another few minutes, a few seconds. Okay, I'm going to go ahead and close this, and I will share the results. So 68% of you said yes, 4% said no, 17% said depends on whether Ted frequently makes comments like this, and 11% said the answer depends on whether Ted supervises Lily.
Okay, great. So the answer to this one is yes, because this is quid pro quo sexual harassment. Ted, asks Lily to do something for him, and if she does, he says she'll get a good bonus. So it's the exchange of something for another. So let's talk about why C is not the answer. So C is not the answer because one incident of quid pro quo harassment is harassment. It's only hostile work environment that requires it to be severe or pervasive. Why isn't the answer D? So the answer isn't D because even if Ted doesn't supervise Lily, he didn't say, I'll give you a good bonus this year. He says you'll get a good bonus this year. So let's think about a scenario where maybe Ted and Lily are at exactly the same level, but Ted is good friends with the supervisor. And so the implication is that if Lily does not give him a shoulder rub, then Ted might, put a word in with the supervisor and say, Lily's she's not performing well. I just want to let you know she's having a lot of issues. She's, not pulling her weight on the team, something like that. So there's no requirement that quid pro quo harassment be done by a supervisor. A couple of other things that people have brought up with this. So one is, since we just talked about what unwelcome conduct is, how do we know that this is not welcome conduct? How do we know that Ted and Lily don't have, some kind of relationship? Well, I would say it's extremely unlikely here because if Ted can get a shoulder rub because he and Lily are dating or because they're friends who just do that to each other, then why does he have to offer a good bonus to get the shoulder rub? And then the other question I got is a shoulder rub necessarily sexual? I think that depends on, both the intent of the person doing it and the person receiving it. But I think in this context, he asks her in a hushed voice. That indicates that he has some awareness that this is inappropriate workplace behavior. I think, most people would think maybe a sort of casual pat on the shoulder isn't necessarily overtly sexual. Now, it could violate a workplace policy against physical contact. A shoulder rub, I think we're getting into some sexual behavior, and people can differ on that one. All right, move on. So this is kind of a long one, and my understanding is there is not a poll on this one, but we'll discuss it anyway because I think it's important. So Carol and Dan work together. Carol asks Dan out on a date. Dan has had a crush on Carol for a while and accepts the invitation. They have a nice first date, but Dan isn't interested in going out again. When Carol asks him on another date, he says no. Then Carol starts wearing provocative clothing at work. She often walks past Dan's desk and asks him whether he likes the way she looks. Dan tells her to stop because her behavior makes him uncomfortable. Carol's behavior becomes more aggressive. She frequently stands close to Dan and tells him to look at her. She also brings in photos of herself in bathing suits and form-fitting clothing that is not appropriate for work. She sometimes leaves the photos on Dan's desk. Dan is so distracted by her behavior that his work performance starts to suffer. He can't concentrate, and he tells his supervisor that he's having anxiety attacks as the result of Carol's behavior. So I guess I'll make this a little simpler by saying that, yes, this is unlawful harassment, but I want you to take a minute and look at the scenario and try to figure out where you think the harassment began. At what point? Was it right at the beginning? Was it not until the end? Was it somewhere in the middle? After which sentence did harassment begin? And I will tell you this one has a lot of gray areas, and I'm not 100% sure what I think or what a court would decide or what would violate particular internal policies. But we'll talk about it. So take a minute and think.
we do have a couple of responses coming in that I'll share with you, Rebecca. So we've got
great.
We have one response saying when actually a couple now coming in saying when the photos came into play. Somebody's responding when Dan said to stop. One is saying when she began to wear provocative clothing. More agreement around when he told her to stop.
Okay. Great. Well, let's talk about it. Okay. Yeah. No, these are actually these are really good. And again, I said this is probably one of the real gray area hypotheticals I'm giving you. So let's say right off the bat, it's not harassment to ask a coworker out on a date. It's not harassment to ask the coworker out on another date. But Dan says no. So at that point, Carol starts wearing provocative clothing at work, so she changes her behavior. So I personally would not say that that's where the harassment begins. She changed the way she dresses. Now, she might be violating office policy, but I don't think that just starting to wear provocative clothing at work, as long as she's not, and first of all, everybody has a different definition of what's provocative, and that's valid. And as long as she's not, directing her behavior towards Dan, we might know why she's wearing provocative clothing, but I don't think that that's enough to constitute harassment. So then she often walks past Dan's desk and asks him whether he likes the way she looks. To me, that's where the harassment begins, because Dan has made it clear that he is not interested in her. And she's asking him to pay attention to her physical appearance. She has to know at that point that that's not welcome, because he's already told her he doesn't want to go out again. He does not want to date her. So that's my opinion of where the harassment begins. That's where I think a court would come out. But I don't know. I'm not a judge. So then going on, Dan tells her to stop because her behavior makes him uncomfortable. I think there's a really strong argument that after that it is harassment, because then her behavior becomes more aggressive. And at that point, maybe he didn't mind that she asked him whether he likes the way she looks. But then he says stop. And so there's just no way to argue at that point that this is welcome conduct. And then, okay, so she frequently stands close to Dan and tells him to look at her. I think, this is getting sort of more severe and pervasive, if you remember the language from hostile work environment. And then one person said that they think that the harassment started when she brings in photos of herself in bathing suits and form-fitting clothing that's not appropriate for work. I think at that point, bringing in the photos and, leaving them on Dan's desk so that he can see is just so clearly overtly sexual and unwanted that by now we cannot deny that harassment is occurring. And then by the time, he's so distracted that his work performance starts to suffer, we've really established hostile work environment, because this is interfering with his ability to perform his job. So I'd actually like to stop again there because I think that's a complicated hypothetical, and just see if anybody has questions about that one. Any questions come in?
I don't see any right now, but if you guys do have questions, please drop them in the questions box and we can get you an answer.
We'll answer them later. Yep. Okay.
Oh, well, so we do have one question.
Okay.
Does it matter when the harassment begins?
That's a great question in terms of does it matter? No. I mean, if all of this happened and Carol went and sued in court or filed an internal complaint, No, it doesn't matter, because in the end, she was harassing him. So I guess the exercise in that we did in at what point the harassment begins, and I should have made this clear. What I was trying to ask is, what if that's all that happened? So what if we cut this hypothetical off at aggressive, right? So we don't have the part where she brings in photos of herself in bathing suits. Is that enough to constitute harassment? So that was my question. All right, let's talk about what exactly unwelcome conduct means. So conduct, as we saw with Carol and Dan, can begin as welcome, but then become unwelcome. And the person engaging in the conduct has the duty to ensure that his or her behavior is welcome. Keep in mind that employees may not feel comfortable telling their supervisor or even a coworker to stop. So courts will use the reasonable person standard. And when an employee exercises control over another employee, for example, the supervisor-supervisee relationship, it is important to be especially vigilant of conduct that may make the subordinate employee uncomfortable. So what does a reasonable person standard mean? Let's say the employee or the supervisee did not say no when the supervisor was making sexual jokes in front of the supervisee. And let's say the supervisee was even laughing because she felt that she had to. You know, this is somebody who controls her job. So then if it becomes sort of a he said, she said, and the supervisor is saying, well, she was laughing, that to me, you know, indicates that she liked these sexual jokes. And she says, well, I felt like I had to laugh or I would lose my job. So courts will say, what would a reasonable person do in that situation? And what that really means, what reasonable really means, is kind of a more than 50%. What would more than 50% of people who were in that position, what would it have meant if they were laughing at these jokes? How would these jokes have come across to them? And I think a lot of people, even people who would never intentionally engage in harassment, people with the best of intentions, often have difficulty determining whether conduct is friendly or unwelcome. So to determine if your own behavior is unwelcome, here are some questions you can ask yourself. Is there equal power between me and the person I'm interacting with? And again, that's keeping in mind that if you exercise control over someone else's job, or have any other, if there's any other power dynamic between you, maybe you're closer to the city manager, maybe you've been at the agency longer and you know, just have more seniority. So always keep in mind that the person that you are joking with or, you know, patting on the back may not feel comfortable saying no. Is there equal initiation and participation between me and the person I'm interacting with? So let's say you are hugging a person every day, and that person hugs you back. So one thing you might want to just stop and think about is, does that person ever come up to you and hug you, or are you always the person initiating it? Does the person I'm interacting with give any verbal or visual signs of discomfort with my conduct? So again, it doesn't have to be no, but what if it's kind of, you know, backing away a little bit? What if it's, you know, what if there's a look in their eyes that they just don't want it? What if their facial expression changes? You know, anything that indicates that they're not enjoying themselves at the moment. What conduct is sexual in nature? There's some extremes, and then there is some, as you know, a lot of gray area. So here are some things that can constitute sexual in nature for sexual harassment purposes. Doesn't mean they always do. We have to look at the specific examples. So depictions of persons in non-work appropriate clothing. And I should always add, as long as there's no legitimate work reason to be showing someone those pictures. I'm a labor and employment attorney. My colleagues and I are constantly looking at pictures of people in non-work appropriate clothing because they're sent to us by our clients. And we have to look at them and say, could this be part of a sexual harassment claim? So, I find my colleagues and I sometimes looking at pictures of naked people, but it's not for our own personal pleasure or humor. It's because we have to for our work. That's obviously not sexual harassment. Depictions of people engaging in sexual or romantic acts. Discussions about physique, appearance, or sexual or romantic acts. On the note about physique and appearance, I think a lot of people find that really tough. And I get a lot of, are you allowed to blank? Are you allowed to tell a person that, you like their shirt? Well, to me, saying I like that shirt is different from saying, wow, you look great in that shirt. A lot of it has to do with your individual relationship, the tone, how close you are to them, how often you say that, what other dynamics there are between you. So this is where I really start to get a lot of, well, am I allowed to? Am I allowed to? And I can't always answer it because so much depends on context. Am I going to say that you're never allowed to tell a coworker that they look nice that day? Absolutely not. That's part of a lot of human interaction, but there has to be some reasonable assurance that the person on the receiving end of that is participating and enjoying and welcomes those comments. Discussions about physique, I would say, be a little more careful with. There's a difference between saying, I like your shirt, and hey, that shirt, really fits you well. Requests of another employee to engage in sexual or romantic acts, even if you're joking. Repeated requests to go on a date. So coworkers, unless there's an agency policy against it, are under the law allowed to go on dates, become intimate, become romantic, get married. But repeated requests where you get a no for an answer could be sexual harassment. And then requests for physical conduct, even if not overtly sexual, are still considered sexual in nature for the purposes of sexual harassment. And hugging and shoulder rubs are common examples of that. And then jokes, a really common defense that people use when they're accused of sexual harassment is, I was just joking. And often that's true, and the person didn't necessarily mean anything, mean or offensive by it. But it doesn't matter. Intent doesn't matter. It's the words that matter. So the only, bright line rule I can tell you is, or bright line advice is, when in doubt, just don't do it. Save it for friends outside of the workplace. Why risk getting into a situation where you may be accused of sexual harassment? All right, so I have to warn you, I'm going to skip over some slides. Often when I get really great questions in these presentations, I know that I'm going to run out of time at the end. So I will be skipping over some slides to make sure that we cover everything. Don't worry, I'm not going to skip over anything that you would be required to hear from me in order to get credit for this training, and you'll be getting a copy of this at the end, so anything that I don't talk about on a slide, you will be able to see anyway, and you can always follow up with me if you have questions about it. Here's just a list of things that many people do not know. I think to some of you, this is going to be really obvious, and then I find that a lot of people are very surprised by this. So harassment can occur between any two coworkers, regardless of their position. A supervisee can harass a supervisor. Women can sexually harass men. I think most of us know that by now, but I always get one person in the audience who's surprised by that and still thinks of it as this, again, quote unquote, old school sexual harassment. Sexual harassment can occur between two women or two men. Sexual harassment, and I should say, can occur between two women or two men, regardless of sexual orientation. A straight woman can sexually harass another straight woman. And the reason is that sexual harassment does not have to be motivated by sexual or romantic desire. So sexual harassment is about power. It's not about feeling romantic towards someone. And harassment based on a person's gender identity, gender expression, or sexual orientation is prohibited regardless of motive. So, you may be very, a word I recently used or recently learned, woke, which I think tends to mean progressive. And you really are, just making a joke. Maybe you even belong to one of those groups, or you have a family member or a friend is, you're very accepting. But if you're harassing somebody based on their gender identity, gender expression, sexual orientation, etc., and remember, that can just be a harmless, or to you, harmless joke, you could still be liable for offensive conduct. And I was joking is never a defense. Okay, so let's talk about procedures. What should you do if you experience or witness harassment? Always do something. So if you experience harassment, I always say if you feel comfortable doing so, tell the person to stop, but that's not always realistic. It's really important to report the conduct immediately. You may feel like you don't want the attention on yourself, you can live with this conduct, but what if the person is doing it to someone else? Inappropriate conduct really needs to be stopped. If you don't feel comfortable reporting the conduct to your immediate supervisor, you could report it to any supervisor or manager, to HR, or to any person designated by your employer to receive complaints. And so that kind of addresses what we were talking about earlier, that I'm talking about sort of a range of options, but your employer may have a specific policy on reporting. The law also permits you to report the conduct to the EEOC or the DFEH, that's the state equivalent of the EEOC, without reporting it internally. So I will often hear, let's say from an HR director, oh my gosh, we just got this complaint from the DFEH. Somebody complained about harassment or discrimination, but they never told me about it. So how can the city be liable when they never reported it? Well, the answer is the law doesn't require reporting it internally. You can go straight to a government agency. And retaliation for reporting harassment is illegal. It's as illegal as harassment itself. Under the law, you cannot be punished for making a good faith report of conduct you believe to be unlawful harassment. So that means that, let's say you believe that you're being harassed, or you believe that somebody else is being harassed. You report it to HR, an investigation is done. The investigation concludes that what happened was bad, but it wasn't unlawful harassment. You're still protected from retaliation because you made a good faith complaint. Even if the law says that it wasn't harassment, you were making a harassment complaint. And then what do you do if you observe harassment? So if you believe that you have witnessed harassment, you really have to report it to your supervisor or other person designated by your employer. If you are not a supervisor or manager, you're not going to be held liable personally for not reporting it, but your employer is still going to be held accountable. So, just try to protect everyone in the workplace. If you are a supervisor, you should discuss the situation with the person you believe was subject to harassment to make sure that he or she understands that the issue is being addressed. That's really the most important first step to take. If you're not comfortable having that conversation yourself, you can always ask another supervisor or HR. Ask the person whether he or she feels comfortable in the current situation. And if not, discuss what measures can be taken to make the person feel comfortable while the incident is being investigated. That may include moving the person into a different working group, physically moving their office, sometimes, allowing them to work from home or even taking paid administrative leave. This is really specific to the situation. So once an employer receives a harassment complaint or report, it must take action to conduct a prompt and thorough investigation and to promptly respond to the charge. So it is not necessary that the complaint or report be in writing. It can be, I will often hear, well, the person didn't file a formal complaint. That's okay, they didn't need to. Somebody turning to you and casually saying, my supervisor has been touching me, or my supervisor has been making me really uncomfortable with her comments. That's a complaint. You are now the recipient of a harassment complaint. And it's never the employer's duty to determine at the outset whether harassment has occurred. So the employer, and when I say the employer, it's often an HR manager or director. There is never a duty to, and in fact, I think you probably shouldn't say, all right, you reported harassment occurred, or you reported harassment, I don't believe you. It's not your duty, you shouldn't be doing that, even if you feel very strongly that you know what happened. So then interim measures should be taken to ensure during the investigation that the complainant or victim is not subjected to further harassment. You're just increasing liability if you don't do that, and that may include separating the employees, but the separation cannot be punitive towards the complainant. Harassment investigations should be conducted by someone able to be impartial. Often that's not the person within the agency who would usually conduct investigations. So let's say the HR director would usually conduct the investigations. And let's say the HR director's manager or direct subordinate is implicated. Well, the HR director in that case may not be able to be impartial, and the right thing to do in that case would be to hire an external investigator. Confidentiality should be maintained to the extent possible, but it should never be guaranteed to the complainant because there are going to be people who need to know. The investigation has to be completed, even if one of the parties involved leaves employment, and a written report should be prepared. That protects the agency. This is one that very commonly comes up. So there's been a harassment complaint. If the person accused knows they did it, often they'll resign. And if they don't, then sometimes the complainant will resign and say, this was essentially a constructive termination. I couldn't work in this environment. The investigation still has to be completed because the problem hasn't been solved. If harassment occurred, it occurred. If harassment occurred towards one employee, it could have occurred towards others. And it's really important to understand what happened. Everyone who participates in the investigation should be told not to retaliate and not to discuss the investigation with others. Retaliation is a really serious offense that warrants discipline. So we talked about how retaliation can occur even if the investigator concludes that harassment has not occurred. Courts take, in my experience, courts have been taking retaliation a lot. I don't want want to say they've been taking it more seriously than harassment, but I will say more often a court will find that retaliation occurred than that they found harassment occurred. And here's why. It's really difficult in a lawsuit to establish that sexual or other harassment occurred. There's more sort of subjectivity involved. It's often, different witnesses saying different things. There are those gray areas, but retaliation is often more overt. So if a person files a complaint and then was treated differently in an adverse way, that tends to be more black and white. And unfortunately, we do see people getting fired after making harassment complaints. And sometimes the employer doesn't even realize that what they're doing is wrong. They saw it as, well, this person just keeps complaining. We can't have a complainer in the workplace. Okay, but they're not complaining about the air temperature, the carpet texture, the griping that they don't like their coworkers. You can't fire somebody for making a harassment complaint. So what are some typical provisions in an anti-harassment policy? Definitely a definition of harassment, and my personal advice is to err on the broader side. You can always decide that somebody, was in a sort of gray area within the policy and say, okay, there's room for interpretation here. I don't think this was harassment within the policy, so I'm not going to find that there was harassment. But if you err on the broader side, at least you're going to protect yourself from having the agency be liable under the law. There's usually a zero tolerance for harassment. That does not necessarily mean that somebody who is found to have harassed someone else is immediately fired, but it does mean that they're immediately disciplined, and it can mean immediately fired. A list of people to whom harassment must be reported, what the employer will do when they receive a harassment complaint, assurance of no retaliation, and a list of possible consequences for engaging in prohibited harassment. I actually find the last one to be really important. Again, you can fire somebody who sexually harasses another person. But I often hear that employee is saying, well, it doesn't say in the policy manual that I can be fired for harassing another person. Most employers do not require progressive discipline where severe harassment occurs. So I think it's just a good idea to list out all the possible consequences. If you want to make it as minor as first time you get, a reprimand, always include, up to possible termination. Okay, so what's an employer's responsibility for off-duty conduct? So in order for the employer to avoid strict liability for a supervisor's actions, the harassment must result from a completely private relationship, unconnected with the employment. Otherwise, the employer is strictly liable for the supervisor's actions, regardless of whether the supervisor was acting as the employer's agent. So I'm going to just break that down. Employers are generally liable for supervisors' off-duty conduct. The exception would be if there is an event or a relationship that truly has nothing to do with work. So let's say these people, two people are, let's say they were friends before they even started working together. They often go to parties together. The party has nothing to do with work. The supervisor didn't pressure the other person to go to the party. It's just a mutual friend. Harassment occurs in that context. The employer wouldn't be liable for that. So I'm going to just go through a couple of examples of off-duty conduct and talk about whether that could be unlawful workplace harassment. So let's say a few coworkers meet for a drink after work, and one of them inappropriately touches another. I think, this one kind of depends on how this gathering arose. Was it a supervisor saying, hey guys, I want to take you all out for drinks after work, and then, he touches one of his subordinates? That probably would be considered workplace harassment. And again, this one really has to do with whether or not the person exercises control in the workplace over the others. I would say if these are coworkers of sort of equal level within the agency and they just spontaneously decide to go out for a drink and one of them behaves inappropriately, probably wouldn't be considered workplace harassment. Still could be harassment, but not workplace harassment. A department head invites all department employees to meet for a drink after work, and the department head uses an offensive slur to refer to a gay coworker who is not present. I would say that definitely is unlawful workplace harassment. I think it's reasonable to assume that if it's a department head inviting all department employees to meet for a drink, there's an expectation that they will go, so there may be some pressure. This sort of becomes a workplace event. And it doesn't matter that the coworker that he's joking about isn't there. It's still an offensive slur. Two employees are hanging out on their break in the lunchroom. One of them shows the other graphic photos on her phone. So let's, assume that these were unwanted graphic photos. It happens on a regular basis. It doesn't matter that they're on their break. They're still in the workplace. So, in that sense, it is technically off-duty, but it's still workplace harassment. The last one's probably fairly obvious. So the agency invites all employers to a holiday party. Attendance is completely optional. At the party, a female employee makes fun of a male employee for, quote, dressing like a girl. It does not matter here that attendance is completely optional. This is an agency event, and so again, employees aren't being paid to attend. It's off-duty, but it's still workplace harassment. All right, so we're going to talk for a minute about gender-based harassment, which is different from sexual harassment. 50% of individuals who identify as transgender or whose gender does not conform to traditional male-female binary categories say that they have been harassed in the workplace. California law now requires employers to allow employees to use the restroom that matches their gender identity regardless of their biological sex. California law also requires employers to allow employees to wear clothing that matches their gender identity or gender expression, regardless of their biological sex. So I've been working recently with a lot of employers to kind of rewrite their dress code because you'll find things in, very commonly in typical dress codes that say women are allowed to wear X, men are allowed to wear X. Not a good idea anymore. There should be universal rules for employees. So, for example, a decade ago, a policy might have read, women are not allowed to wear a revealing neckline. Let's change that now. Employees are not required to wear a revealing neckline. So harassment based on someone's gender identity, gender expression, or sexual orientation is unlawful, even if it is not sexual harassment. Gender-based harassment may include negative comments about transgender or other people whose gender identity or gender expression is different from the sex they were assigned at birth. Can include slurs, insults, stereotypes, offensive jokes, refusal to address a coworker by their preferred gender pronoun, refusal to accept a person's gender identity or gender expression, including refusal to accommodate how they dress or what bathrooms they use. I'm just going to go back to that. So I want to pause again for questions, and we'll have an opportunity in less than 20 minutes to ask any final questions after I go through a few more slides, but I feel like I just gave you a lot of information, so ask away.
And we do have a couple in the queue here. One has to do with reporting. The question is, what is the duty of a coworker to report harassment in the event that the victim requests that no report be made?
I don't think I understood the second part of it. So I understood what is the duty of a coworker to report harassment, and then what was the second part?
My understanding of this question is, so a coworker confides in another coworker about a harassment situation, but asks that they don't share that information. What's the duty of the coworker to report in that situation? So if you're asked to not report it?
Understood, yeah. So this happens very frequently. You are still under a duty to report it. So once a person complains about harassment, whether or not that harassment complaint is passed on to a supervisor or HR is not their decision, and whether or not it's investigated is not their decision. Yeah, so that is the answer. It's not illegal. So again, a coworker who fails to report harassment, it's not like you can personally be sued in court, but the agency as a whole can be held liable for failure to prevent harassment if you don't report it. And then it may be subject to discipline under internal policy.
Okay, thank you. Another question we have is about accidental touching of in the workplace. So if it's a one-time situation where you accidentally brush up against somebody, or a scenario like that, would that be considered harassment, or could that be considered harassment?
Well, there's a general principle in all laws that if something is truly an accident, meaning that, say you're walking down the hall, you trip, and in tripping you bump into another person and maybe, touch them in a private area. No, that is not harassment. And I think that's what the question meant. I would distinguish that from you touch a person intentionally, but didn't realize that the way you were touching them was harassment. In that case, you can still be liable. But a true accident, no.
Okay. This one, we have one about retaliation. The question is, if somebody is consistently calling the EEOC in retaliation to a person who made an original report to the EEOC, is that harassment? Is that...
Okay, so the scenario that I'm understanding is somebody made a harassment complaint to the EEOC, and in response to that, somebody else is calling the EEOC against that person who made the complaint. Is that how you understand the scenario?
Yes, that's my understanding of the question.
So I don't think that's I don't think the second person is harassing, but they could definitely be retaliating if the reports are not in good faith. That's what it depends on. So if they're calling the EEOC against that person, making false complaints to retaliate for them making a complaint, that, yes, that is retaliation. But if the person who called the EEOC initially was engaging in harassment themselves and somebody calls the EEOC on them, that's making a good faith complaint. So it really depends on what the reason is for a particular action. If it's to retaliate, it's retaliation. But it's possible that a person is making a harassment complaint and engaging in harassment at the same time. And so if you complain about that person for engaging in harassment, then you're not retaliating if you really believe that they are.
Got it. Great. One final question that I think come in as of now has to do with social media, which is, I'm sure, another gray area that you're trying to navigate right now. The
Yes.
question is, what if a coworker posts racial or gender-based comments that offend another coworker on her private Facebook page? Could that be considered harassment?
That is most likely not workplace harassment. Is it harassment? Could be. But we're talking about workplace harassment specifically now. There are gray areas. If they are interacting on social media in the context of being coworkers, it could be workplace harassment. If you just happen to see this on somebody's Facebook page, then no. There are definitely First Amendment rights at stake here. People are permitted to express private viewpoints on private media or private social media. When those comments are targeted at a coworker, that's something different. So it's tough to answer that question without knowing all of the facts, and I hate to just default to there are gray areas, but I would have to know a lot more details.
Great.
Anything else?
That's all we've got for now, but
Okay.
we do still have a little bit of time, so if there's more questions,
so
keep them coming.
Yep. Okay. So I'm going to skip ahead a lot just because I want to make sure that we get to abusive conduct, because that is a required part of your training. If we get through abusive conduct and there are no more questions, then we'll go back to some of these hypotheticals. I just want to make sure that you guys all can get your certificates. So employees are required to receive training to prevent abusive conduct, even though abusive conduct is not illegal. Very commonly misunderstood, and for good reason. It kind of makes no sense. The only way I can explain it is that the legislature wants to create more pleasant work environments, which I think is quite legitimate, but hasn't yet been able to make a law that actually regulates abusive conduct because, as you've heard me say a million times, there are gray areas. One person's abusive conduct is not necessarily another person's abusive conduct. It can be subjective. But here is how the legislature has defined abusive conduct. This is a real mouthful. So it's conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets. Verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act shall not constitute abusive conduct unless especially severe and egregious. So as you can see, there are some words in here that different people would have definitions of: hostile, offensive, severe, egregious, threatening, intimidating, humiliating. That's why it's really tough to make laws. But I think this is a pretty detailed one and provides a roadmap for employers who want to adopt an internal policy of abusive conduct. I think this is a good definition to use. And I think it's important for employees to understand that if they get yelled at once, it might be really inappropriate and not good supervisory conduct, but it's probably not abusive conduct that would necessarily subject a supervisor to discipline. So abusive conduct is different from unlawful harassment because it need not be based on a protected status. So we talked about the protected statuses: race, gender, pregnancy, etc. And if you remember our first hypothetical about George, who's screaming and humiliating Alberto, and we decided it probably wasn't unlawful harassment because it had to do with George dating Alberto's sister, which isn't a protected class. It can still be abusive conduct. And abusive conduct is more than bad boss behaviors. Unfortunately, there are a lot of bad bosses out there. Before I came to my current firm, I've had a lot of bad bosses. But abusive is more than that. Conduct does not have to rise to a level, though, where it would create criminal or civil liability in order to be considered abusive in the workplace. So I see, a fair number of lawsuits filed that allege intentional infliction of emotional distress. That is a standard cause of action, but something can be less than that in order to be considered abusive conduct. You don't have to be intentionally inflicting emotional distress on somebody. If your behavior is egregious enough, it doesn't matter what your intent is. All that said, we don't know what a court would consider abusive because abusive conduct is not yet prohibited. And employers are permitted and encouraged to develop their own definitions of abusive conduct and to prohibit abuse of fellow employees. All right, before we get to the questions, since we still have 8 minutes left, I want to go through one more hypothetical. I'm trying to figure out which one. Okay, let's do this one. Okay. Ted is a manager in the recreation department and often tells sexual jokes in the lunchroom. The jokes are not directed at anyone in the workplace. Mike, a manager in a different division in the same department, finds the jokes funny and sees that most of his other coworkers are laughing at the jokes. Then one of Ted's direct reports, Kelly, tells Mike that the jokes make her feel harassed because she is female. Mike tells her that she is being too sensitive because the jokes are about males and females. He doesn't tell anyone what Kelly told him and doesn't confront Ted. He thinks, if I do nothing, Kelly will get over it soon. Did Mike do anything wrong? Do we have polling for this one?
We do. Let me, I was just trying to unmute myself.
Okay.
So let me go ahead and launch this one for you all. Okay, another quick poll here. In this scenario, did Mike do anything wrong? Most of you have already voted, but we'll give this just a few more seconds to get everybody a chance to respond. right. Let me close this and I'll share the responses really quickly. So the most common answer with 60% was that yes, Mike's the supervisor and therefore has to report all complaints. 36% say yes because all sexual jokes could constitute sexual harassment. And then at 2% each, we have no because Mike does not supervise Kelly, and no because the jokes are not specifically aimed at men or women.
Okay, perfect. So the answer is D. Kelly has made a sexual harassment report, so he is required to report it even if he doesn't personally believe that sexual harassment occurred. Doesn't matter that Mike doesn't supervise Kelly, he is a supervisor. I wouldn't say that all sexual jokes constitute sexual harassment because, again, it has to be unwelcome. So if everyone who's listening enjoys the joking, participates in it, isn't offended, then it may still be bad workplace behavior, but it wouldn't be sexual harassment. And it doesn't matter that the jokes are not specifically aimed at men or women. They are still sexual jokes, and so they can, in this case, constitute sexual harassment because Kelly feels harassed. Now, this doesn't mean that this necessarily is sexual harassment. We'd probably have to know more, but the question is just, did Mike do anything wrong by not reporting it? Okay, so since we have 4 minutes left, I do want to open this up to questions. And then I'm just putting up my email and phone number in case you have questions that can't be answered today. I do have to caveat this by saying I would not be allowed to give you specific legal advice unless you're a client, and some of you may be. But I can certainly answer any general questions about the presentation, anything that was unclear to you. So feel free to follow up with me. And we have a few minutes to take questions now.
Great, thanks, Rebecca. And just to remind folks, we will also be distributing the PowerPoint with a follow-up email. So you'll be able to review all of the content that we had to kind of run through quickly and refer back to anything that you might have questions on after the fact as well. We do have one question that has come in around abusive conduct. This is related to interactions with the public, and so I'm not sure how this applies, but would love your thoughts on this. Any recommendations for cities on how to deal with what this person is calling abusive conduct from a member of the public towards city staff? So I'm assuming this is potentially in public meetings or city council meetings or other things like that where they have a particularly contentious member of their community.
That's right. So I guess I'll first say that because I'm a labor and employment attorney, I don't have expertise in dealing with members of the public. That's a whole separate area of the law. I do workplace issues. That said, there is an aspect of this that relates to the workplace. And employees do have the right to protection from a member of the public. So I can't advise you on how to actually deal with that member of the public, but I can tell you that if an employee is repeatedly being abused or harassed by someone, there is an obligation to remove the employee from that situation. Sometimes that's a lot easier than other situations. Sometimes it may be almost impossible. But let's say somebody sits at a customer service desk, a member of the public comes in every day and insults them, on the basis of race or religion or one of these protected classes, or is just screaming at them and treating them horribly. There would be a duty to see if that employee can be removed from that situation. That's what my expertise can offer. I would certainly have to refer you, though, to a different lawyer in terms of what you can do to prevent that member of the public, if anything, from continuing that conduct.
Great, thank you. It's all I'm seeing right now from the group. Make sure I didn't miss anything here. Yeah, when we are right about 10:30. So again, if you have outstanding questions that you didn't get a chance to type in or come to you later, please feel free to reach out. In terms of our closing here, just again, please expect your certificates via email by the end of this month, and don't hesitate to reach out to me at ILG if you have any questions on process or anything there. Rebecca, any final questions or comments for the group before we close out?
Just thank you very much for participating. Your questions were really great. It's really interesting to see what people answer to these questions. You know, as I hope I made clear, sometimes there is no right or wrong, and even if there was and you got it wrong, don't feel bad. A lot of people do. I hope you learned something, and have a great rest of your day.
Great. So definitely want to reiterate Rebecca's thank you to our attendees today. Thank you for joining us this morning, and hope you enjoy the rest of the League conference if there's anything else you're going to attend today. And a big thank you, Rebecca, for sharing your experience and expertise with us this morning. Really appreciate you taking the time and for your continued partnership.
And thank you so much. Yes, thank you for all your help and support and for hosting this.
Great. All right, well, with that, I hope everybody has a great Friday and a great weekend, and hope to hear from you soon.